one now.
Oh, I'm recused.
SJC-11664, Commonwealth v. Razak Oyewole.
May it please the court.
Wait a minute,
Stacy-
hang on.
I apologize. May it please the court. Stacy Silvera for the defendant, Razak Oyewole. With me at counsel table is Attorney George Olson, who is Mr. Oyewole's trial counsel in Woburn District Court. By way of brief introduction for the purposes of this argument, I would like to focus on two areas that are the crux of this case. First, the nature of the judicial record, and second, the operation of the statute at issue, Chapter 90, Section 23. The Commonwealth is asking this court to speculate and to make the implicit assumption that there is a uniformity of proceedings across the Commonwealth, 351 towns and cities, 62 district courts, approximately 160 district court judges, that plea colloquies are there's a uniformity of proceedings in plea colloquies. Such an assumption would be a stretch and likely highly improbable.
Well, we hope there's some uniformity. I mean, there are some constitutional issues at stake, so there is indeed lots of uniformity, and there should be.
Absolutely, and there's no disagreement in that. And in fact, I would suggest to you the onus, despite this case that arose originally, the underlying case was out of Lowell District Court, and it's an incredibly busy courthouse, and the trial judges all work very hard. The onus is on the trial judge the onus should be on the trial judge at the end of the plea colloquy to state to a defendant
What the sentence is.
what the sentence is.
And
Exactly. But the problem with this case, Your Honors, is that there is no evidence before you, not one shred whatsoever, from the docket, the only evidence produced at trial by the Commonwealth, that notice was given to the defendant. Any type of notice.
Now, I assume you'd be in a very different posture if the docket made a reference that said a defendant present in court and notified of the suspension.
Correct. I'd be in a different place. I might not be here before you, but I would still be arguing it below that perhaps that wasn't sufficient notice. I believe this, when I say that this is...
So what could have happened here that might have avoided the problem that you're raising? Could the probation officer have testified that, yes, I was there, and the defendant surrendered his license to me, and I then mailed it off to the Registry of Motor Vehicles?
Absolutely. The probation officer didn't do that. The inference is that it was not done because the defendant was arrested with a license in his possession. The converse inference can actually be taken that probation didn't follow proceedings either, as they were required to under 24D. Furthermore, the best evidence...
And 24D requires the probation officer to take the license from the defendant?
I think technically, and I'll defer to Your Honors and can file it later if you need, I think it says the defendant should surrender his license to probation.
But it's to the probation office, not to the clerk.
Probation officer, not to the court, not to the judge, not to the clerk magistrate, who at times reads the disposition into the record. But that being said, the onus is on the judge to read the sentence and say not only what the sentence is, but in a case like this, that the suspension is available immediately. Going back to what the first point, which was the judicial, what constitutes the nature of a judicial record, here it directs quickly, your point is applicable because a copy of the plea colloquy would have sufficed easily. This was a case where the defendant was pulled over approximately 30 days or 36 days after his admission to sufficient facts. There's no reason why the Commonwealth could not have simply gotten a copy of the colloquy and entered it into evidence at trial, if it so wanted to. We don't have evidence.
But what if the colloquy said exactly what you just suggested, and the license in fact had been surrendered to probation, and probation in fact sent the license to the Registry of Motor Vehicles? How do we know that the Registry of Motor Vehicles didn't give the license back to the plaintiff by mistake, or to the defendant by mistake, and so he had it at the time that he was arrested?
That's all, on the facts of this particular case, that's all irrelevant. in the sense
Well,
that...
so the only way that we can rest assured that a defendant was notified of his, of the revocation of his license was to get something from the Registry of Motor Vehicles to say that we received the license from him and we retained it and returned it to him on such and such a date.
No, there were many ways the Commonwealth could have proven it. In fact, I'd direct you straight to the statute itself. By operation of the statute, the legislature has placed in it a portion of the statute that says a certificate from the clerk stating that, it's the third paragraph from the bottom of Chapter 90, Section 23, a certificate of the clerk of court that a person's license or right to operate a motor vehicle was suspended for a specified period shall be admissible as prima facie evidence in any court in the Commonwealth to prove the facts certified to therein in any prosecution commenced under this section. There's another way it could have been proven up, and that would have been prima facie evidence according to the legislature. They could have put on the probation. They could have done a lot of things. The Commonwealth simply gave the thinnest evidence possible, a docket, a Lowell District Court docket, and that docket happened to include absolutely not one mention of notice to the defendant. The record's entirely devoid of any mention of notice.
And then there was no transcript of the plea colloquy, correct?
There was no transcript of the plea colloquy
Not
entered.
admitted. I mean, I assume there somewhere was a plea colloquy that was recorded, but that's not.
Absolutely, it was not admitted into evidence. It's before the court in my reply brief, and I've discussed with my sister, it was withdrawn, the green sheet, but if we talk about green sheets generally, and this doesn't pertain to my client because the green sheet wasn't entered into evidence at trial, but even green sheets don't suffice. This court said, and I believe Hilaire, which is one of the cases that's cited by the Commonwealth, states that a plea colloquy is the best evidence, not a green sheet. So I think the plea colloquy, the record that was produced in cases where we're looking back at a prior judicial proceeding, the Commonwealth has a responsibility to put in the record that is before it and easily accessible. This isn't a case that we're...
The issue is not whether it's the best evidence. The issue is whether it is sufficient evidence.
Well, the issue is that that is the accurate evidence that's required to put in. With regard to sufficient evidence, I know the dissent in the appeals court, the majority in the dissent argued over whether it was using a civil standard or a preponderance of the evidence standard or beyond a reasonable doubt. But regardless, if you took simply at this point what was entered into it, a docket with nothing more, the inference from the police officer that the defendant was found with the license, there was no evidence, no testimony that that police officer thought the license was counterfeit, was forged, any other thing. It appeared to be a police officer can recognize the driver's license in Massachusetts, and perhaps even take the contrary inference that the Commonwealth chose not to produce the probation officer on the stand or any other information from the prior proceeding. Perhaps it doesn't even meet the preponderance of the evidence standard. It certainly doesn't meet the standard for a criminal case, which is beyond a reasonable doubt. We are talking about a man's liberty at stake today.
And I gather there was no evidence as to what the usual course of practice was in this particular court with regard to a sentence.
There was no evidence whatsoever in the record of the usual practice in Lowell District Court as to how this proceeds. On a personal level, typically in the busiest courts, and I've happened to have worked in Lowell years ago, oftentimes the clerk magistrate reads in the disposition into the record. I think that's common knowledge. And that could have happened in this case. We have absolutely no idea because there isn't a sufficient record.
That would be fine if it included this, right?
And it was either notated in the docket, a certificate from the statute by operation of the legislature which said it would have been prima facie evidence, or some sort of plea colloquy was entered. If the clerk may have very well put a sentence in. We have absolutely no idea what it was because at this point, all the Commonwealth entered into evidence at trial was the docket, not one mention in the docket of notice. If there are no further questions, I would rest on my brief.
Thank you.
Thank you very much.
May
May it please the court, my name is Carrie Ann Kilcoyne. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. The docket sheet here is sufficient evidence to prove that the defendant received notice that his license was suspended.
Why?
The docket sheet is a contemporaneous official court record. It can be presented as prima facie evidence of the facts that are recorded therein. Specifically on the face of the docket sheet, the written judgment is there, which specifically laid out that this defendant was given a continued without a finding disposition for 1 year, enrollment in an alcohol education program, which is pursuant to the 24D program.
But the statute requires not merely that it be suspended, but that there be notice of the suspension. So
Correct, and-
where in the record is there any evidence that the defendant was notified of the suspension?
Well, it suggests that looking at the docket sheet, again, the written judgment includes the 60-day license suspension. It's clear that the defendant was there in court on the day that the case was disposed because he admitted to sufficient facts. The colloquy was given. I think it's a reasonable inference that the sentence is stated. It's the standard part of the plea colloquy.
When did the 60-day suspension take effect?
It took effect upon disposition under
In what-
9024D by operation of law.
Okay, and where in the record does it show that the defendant was notified of that particular effect?
Well, again, I think it's a reasonable inference. This was a 24D disposition pursuant to 24D. The defendant, because this was an OUI first offense, the defendant has to consent to the disposition. It includes a sentence of probation and a license suspension. And again, this was a plea. Generally with the plea, it's, the facts of the case are discussed, whether the defendant has counsel, and that's been discussed.
Aren't you sort of going on the presumption of regularity?
It is part of the presumption of regularity, but again, I think the record of the court, in this case, the docket sheet, has to be evidence of what happened in court. Otherwise, there might be no purpose for the docket sheet itself. The whole point of the docket sheet is to record what happens in court on a particular day, and the case law suggests that actual knowledge of the suspension isn't actually required. There's a whole line of cases.
But it is, but actual notice.
Notice,
is
well,
required.
actually, some of the language in Duramo and Cross-Cup seems to suggest that not only do we have to prove actual knowledge, but I think in Duramo it also suggests that actual notice isn't specifically required, that there is a language right in Duramo that says, according to Cross-Cup, actual notice or actual knowledge is not specifically required. That the defendant has to receive notice. And there's this, the whole line of cases in terms of mailing, and that proper mailing is prima facie evidence that the defendant received notice, that he doesn't actually have to have read what was in that notice. And I would suggest that a docket sheet where the defendant is present in court, it's specifically listed what the judgment was, that could be and should be better evidence than just the notice that is mailed to the defendant that doesn't have to be shown that he actually received it. That again, this was a plea. We know he was in court. The sentencing under 24D requires his consent and includes, as I laid out, probation and a license suspension. The suspension is by operation of law and viewing the evidence in the light most favorable to the Commonwealth, and that inferences need be only reasonable and possible, that here the docket sheet would have been sufficient evidence to prove that he received notice that his license was suspended. If there are no further questions, I would rest on my brief.
Thank you.
Give your attendance at this place on Thursday,